I'm asked about mediation and the benefits that mediation has over litigation and the typical court process in a divorce case. The main four advantages in my mind that mediation has over a typical divorce case are control over the process, the fact that mediation is less expensive, mediation is typically quicker than litigation, and it's more private. Today we're going to talk about control over the process in a mediation case. Hi, I'm John Castellano. I've been practicing law since 1996, and I've been helping families reach the ideal outcome for them since I began practicing. Today we're going to talk about control over the process of your divorce case in a mediation case. The three areas of control that I want to talk about today are the topic or issue that's being discussed in your case, the outcome of that issue, and the comfort level or setting that you resolve your issues in your case. First issue is topic. Imagine you are starting off your case and you're trying to resolve issues in your case. You want to have control over what issues are being resolved. In a courtroom, the court dictates what issues are being resolved based on the issues that are brought before it on typically requests or motions that parties file in the case. You're bound by those issues that are brought before the court at any given hearing, and you can't go outside of those bounds. It's very restrictive. Once you bring those issues before the court, you're limited in what you can talk about on that day. In a mediation case, on the other hand, you are in complete control over the topics and the issues that you can address at any time, on any day. You can change course during any appointment that you have. You set an appointment, you set an agenda, and you try to resolve as many issues as you can. You can resolve the whole case on one day if you want, if you're able to do that. Second issue within control is the outcome of your issues. In a courtroom, you are in a dispute. You are presenting your evidence to a judge, and the judge is applying the law to that dispute. The outcome may be what the parties wanted. It may not be what the parties wanted. It may serve their interests. It may not be anything like what they wanted, and they may be upset about the outcome. In a mediation case, on the other hand, they are in complete control over the outcome. They can come up with ideas with the help of the mediator that serve their objectives, that go outside of the box, that fall outside of what the judge would do, but that serve their interests and that meet what they really want to have happen in their case. The last thing is the setting. Parties want to be in control over the setting and where their disputes are resolved. Imagine you're having your case heard, your important issues in your life resolved. Do you want to have that case heard at a courthouse where you have to travel to a place that you may not be familiar with or happy to go to? You have to park, you have to wait for other cases to be heard before your matter is heard. The seats may not even be that comfortable. Or do you want to have your case heard in a place of your choosing? An office, a hotel banquet room, a Starbucks, any place that makes you feel comfortable and that you choose to create an environment that is comfortable to you and your spouse to discuss the issues in your case. Control is a big aspect to creating agreements that you're going to be satisfied with long after your divorce is over. If you have further questions or we can be of any further assistance to you in your case, please don't hesitate to call us. Thank you.